Privileged communication does not apply in cases of child abuse and neglect. If children, the elderly, or other dependent adults disclose that they're being abused or neglected, the professional is required to report the situation under penalty of fines or imprisonment. The National Child Abuse Prevention and Treatment Act says that physical or mental injury, sexual abuse or exploitation, negligent treatment, or maltreatment of a child under the age of 18, or the age specified by the child protection law of the state in question, by a person who is responsible for the child's welfare, under circumstances which indicate that the child's health or welfare is harmed or threatened thereby. This is a reportable abuse. Counselors should be aware about the limits of confidentiality in these cases that concern HIV and AIDS. What are the matters of reporting in their particular states? Their duty to warn and protect third parties. They need to communicate their responsibilities in these matters through an informed consent. Substance abuse counselors should refer these clients to professionals who can offer assistance in these areas. People like the healthcare departments are really trained in counseling and dealing with these situations. Don't be afraid to refer if it is outside your scope of practice. Counselors really have few guidelines to help them determine when or how to inform a potential victim of the threat of HIV transmission. Again, be familiar with what your state says. The ACA offers some guidelines which suggest that you may be ethically justified in breaching confidentiality to a third party who's at risk. Yet, you may not necessarily be obligated to take this action. Duty to warn and protect may arise when HIV clients continue to have unprotected sex or continue to share needles. Some state laws forbid any disclosure of HIV status to third parties, and others allow some disclosure to at-risk third parties by mental health professionals. This dilemma can be resolved by referring to a legal precedence. You can call your governing board and talk to a legal representative there, or maybe your organization has a lawyer. Find out what your particular state statutes say. What does Idaho say? And also refer to your professional code of ethics for some guidelines on how to deal with the disclosure of HIV/AIDS situation. In conclusion, keep in mind that all limits of confidentiality should be discussed with the client at the onset of treatment through informed consent and reviewed throughout the treatment process. Counselors should be aware of state laws regarding their professional interactions with HIV-positive clients. Counselors need to keep current with regard to relevant medical information related to the transmission of HIV, which practices are safe, things like that. You do have an ethical obligation to help educate your clients. Seek crisis intervention training on this issue. If your client continues to practice unsafe sex or not inform their partners, then you as the counselor need to determine what course of action you need to take. Do you have a duty to warn? Be sure to get supervision on this issue. Consult with knowledgeable peers or attorneys. If it's determined that the counselor should breach confidentiality, inform the client. Try to get their permission. Help them understand why you're doing it. Safeguard the client's privacy as much as possible. Remember that clear and imminent danger must exist in order to violate confidentiality. There must be an identifiable victim for duty to warn.